Hello all. The Supreme Court Chief Justice of India, N.V Ramana, had come up with lot of reforms. And one reform I will be discussing now. With that, the consecutive reforms which have been suggested by N.V Ramana we will be discussing now. The Ramana is the 48th Chief Justice of India from Andhra Pradesh, who is very famous for his inclusive thought process, who is very famous for giving social justice, political justice for all the sections of the country. So in his slew of reforms, the first reform which I am going to discuss today is about the bail approval. What happened, in reality, if the bail plea is there in the court, so the hearing for the bail plea will happen in the court in the afternoon sessions. And the judge will give the approval for the bail. If in case the judges gives the approval for the bail, the time the bail order come to the table, means ground table, from where the court constable will take that bail orders and he will go to the central prison, where he will submit the physical copy. By checking the physical copy, the prison of the superintendent will be releasing the prisoner. This is the procedure. Usually what happens, the bail order will be approved in the afternoon. By the time it comes to the table in the evening, it takes 4:30, and 6 o'clock the prison will be closed. From 4:30, where the courts are located in the center of the city, to the prison which is located in the out of the city, the traveling time itself, it will take lot of time. If they reach by 6 o'clock also, they will close the doors. The bail is given, but the release will happen next day. If it is Friday, then Saturday the release will not happen. The Sunday the release will not happen, and the Monday the release will happen. So the N.V Ramana has questioned this parrot message. In the 21st century, why you are waiting for the parrot message? You can just forward the mail to the superintendent of prison, where he can take the download and he can take the printout and he can release the prisoner. Why this cumbersome process? Why you want a physical copy? He is the person who questioned the format of the bail orders after getting approval from the judiciary. Is it not cumbersome process where we are messaging, in instant messaging, we are having so many number of instant messaging apps are there, but from the court to the prison, compulsory there is one messenger, a parrot messenger. Yes. Is it a very good reform? This is a very good reform which is advocated by the C.V. Ramana. Why you are waiting for the physical copy? You can forward it to the mail and take a printout and release the prisoner on that time itself and by the evening. Don't wait for the physical copy. Then what will happen? The days will be extended. Just you think. If Friday evening the bail order came, and by the evening if that bail order doesn't reach physically to the prison, then Saturday, then Sunday, then Monday evening he will be released. Every time the prisoners will be released in the evenings. See, 3 days. He got bail on Friday, but he released on Monday. This is what which happens in Indian judicial system. This is true. This is a true case. And this is identified by this great personality. I liked this reform. So this person is this great personality who is called as C.V. Ramana, who is making revolutions, who is advising few very great number of reforms to the judicial system. And he is a person who enrolled into the Bar Council, then he became the High Court judge, then he became the Supreme Court judge in the year 2014. His some of the landmark judgments are, is one of the landmark judgment which is given in the month of January 2020 is accessibility to the internet. Accessibility to the internet is a fundamental right which is given by this person. This is the first reform. So what he reformed or what he recommended is, there is no requirement of a man catching the bail orders and to reach the prison. The instant messaging or the mail is enough to release the prisoner from the prisons. The second reform which is asked, the second reform which is recommended by the C.V. Ramana is with respect to colonial law, mainly with respect to sedition. The sedition is against fundamental law. The sedition is against fundamental right. The sedition is a colonial past which is made by the British India. Today also we are having sedition under the section 124A. This person, the C.V. Ramana, the Honorable Chief Justice of India, is against the Seditious Act. The second reforms. So he recommended that there is no requirement of seditious act in this 21st century in the independent India. Why? Because this is a colonial legacy. The second reform which is recommended by N.V Ramana. The third reform, statement of law. The third reform is the statement of law. What happened? For the selection of the CBI director, a committee will be constituted which consists of 3 members, the Prime Minister, the Chief Justice of India and the leader of opposition. And this person who was been appointed as the CBI director, Subodh Kumar Jaiswal, only 6 months is left for his service and he was been appointed as the CBI director. Then he asked CGI, only 6 months is left, why you are recommending him to the CBI director? There should be law which should be applicable to that person also. But within 6 months he is going to retire. So compulsory we have to appoint that person who is having minimum tenure of 2 years. So that the laws which are there which will be also applied onto the CBI director. Why? Because CBI director is in a very good, very powerful post. On this he recommended that. So any CBI director need to be appointed by the appointment committee. Minimum 2 years of tenure should be there. Then the law will be applied onto him. Then he will be the law abiding officer. This is the third reform which is recommended by the N.V Ramana. The fourth, sorry state of affairs in parliament. He is unhappy. What are all the affairs which are happening in the parliament? The discussions which are happening are unhealthy. He reminded when he was in the schools in 1960s, 1970s, the parliamentary discussions were very productive. But now the parliamentary discussions has been reduced. The parliamentary discussions has been reduced. The laws are becoming meaningless. No proper law is coming up. So this person asked that the lawyer should become the parliamentarians. The lawyer should become the part of the parliament, lawmaking bodies. At the same time, the law should be rational. The laws should be logical. The laws should be rational. That is what this person recommended. Sorry state of affairs in parliament. Lack of clarity on laws. The laws doesn't have the clarity. So please make the laws which are having clarity. Please make the laws which are having logical, which are rational. And have a very good discussion. Have a very good debate with respect to the laws. Without debate, the laws are getting passed and it is impacting the public at large. This is the person who is very sad against the parliamentary functioning, which is sad against the state of affairs in the parliament. The fifth recommendation, threat to human rights highest in police stations. Judicial killings. That the most of the human rights violations are happening in the police station. That is 100% true. You believe and I also believe. Keep your hand on your chest and believe it. Yes. We fear to go into the police station. We fear to talk to the policeman. What is this? A colonial legacy. The colonial people had made this mindset that we have to fear for the police. No, they are also a government servant like any other government servant. They are also police officer. They are also a government officer like any other officer. But we fear for the police. So on that note, the most of the human rights violations are happening. The most of the human rights violations are happening in police stations. This is the sixth. So there is a requirement of reforming the human rights violations which are happening in the police station. There is a need for a procedure of standards of procedure, SOPs. What the police stations need to be maintained. And we need to control this custodial deaths. Why? Because Tamil Nadu, there was a custodial deaths happened. Custodial killings happened. So because of which he believed that the most of the human rights violations are happening in police stations. The sixth reform which he asked for, need for separate law enforcement agency for the protection of the judges. The judges were being killed who gave the proper judgments. So those judges who were being given the judgments, they were being killed. N.V Ramana, emotionally he told there is a requirement of separate force. There is a requirement of a separate force which will be protecting the judges so that the judges will act independently. Independent judiciary is the basic structure doctrine of our constitution. So in order to act them independently, we have to give them protection. In order to give them protection, there is a requirement of separate police force for protecting the judges. And the seventh reform which he recommended, Chief Justice N.V Ramana upset with reports on Supreme Court collegium on judges. N.V Ramana. Yes. So the collegium, the 4 senior most judges plus Chief Justice of India. 4 senior most judges plus Chief Justice of India will constitute the collegium, and this collegium will be recommending the judges of High Court and the judges of Supreme Court. But recently there are media reports which questioned the sacrosanct nature, the sacred nature of this collegium system who are appointing the judges. On this note, the Chief Justice of India told that the procedure for the appointments of the judges is happening in a very, very sacrosanct manner. No need to question the credibility of the collegium system. If you start questioning, if the people starts questioning, the credibility which is associated to the higher judiciary will die, which results in the failure of the institution, which results in the failure of the state. So, we are doing proper judgments, we are taking proper decisions with respect to appointments of the judges to the Supreme Court and High Court. There is no need to worry, which is given by the N.V Ramana. In this note, the 7 reforms, very, very famous or popular reforms which were being recommended by the Chief Justice of India, N.V Ramana. On this note, subscribe to our channel. All the best. Jai Hind.